Welcome back to the Constitutional Clarion. Now I know there's been a surfeit of videos this week, but this one is just a quick update on the High Court's decision today in the ASF17 case about the constitutionality of immigration detention in Australia. The High Court, as many of you would know, caused great controversy when it handed down its NZYQ judgment because its ruling caused the release of 153 detainees into the Australian community, many of whom had criminal records. The gist of the court's reasoning was this: it's a fundamental constitutional principle that only the courts can convict and punish people for crimes. The executive government has no power to do so. Now, building on that foundation, the detention of people by the executive will be presumed by default to be punitive, so punishment, and therefore constitutionally invalid unless it falls within a number of exceptions. Now, these can cover a range of things like being detained for reason of mental illness or quarantine, for example, in relation to infectious diseases. One of these exceptions is detaining non-citizens who enter Australia or remain in Australia without lawful authority. They can be detained for the purpose of deciding whether to grant them a visa, or if their application is refused, they can be detained for the purpose of deporting them. However, in the NZYQ case, the High Court held that the detention of non-citizens for the purpose of deporting them becomes punitive if there is no real prospect of their removal from Australia becoming practicable in the reasonably foreseeable future. Effectively, this means that it has ceased to be for the purpose of deporting them if deportation itself is not in practice possible. Now, this may be because the relevant person is stateless and no country will accept them, which was indeed the case in relation to Mr. Al-Khatib from a previous case, or because Australia owes them an obligation of protection under international law and cannot return them to their home country due to the risk that they would face serious harm there. But what about those people who have applied for protection visas and have been rejected because the minister's delegate and the courts, through a process of judicial review, have found that their claims are false and Australia has no obligation to protect them? Ordinarily, these people would be deported, but some countries, such as Iran, refuse to permit the involuntary return of their own citizens. The consequence in those cases is that a non-citizen gets to remain in Australia by default because they refuse to cooperate with their deportation to their home country and they have no right to live in any other country. ASF17 fell within this category as he refused to cooperate by seeking travel documents from Iran and he refused to agree to his deportation. This meant that Iran would not take him and Australia could not deport him. He then claimed that this meant that his detention in an immigration detention facility was invalid because there was no real prospect of his removal from Australia becoming practicable in the reasonably foreseeable future. He argued that his detention was therefore punitive and constitutionally invalid, so he had to be released into the Australian community. The High Court in ASF17 rejected this argument. If he had the benefit of a protection finding, then the court said it would have been punitive to keep detaining him if there was no real prospect of his removal from Australia becoming practicable in the reasonably foreseeable future. But no such protection finding had been made in relation to ASF17. Equally, if he had suffered from some kind of incapacity that prevented his cooperation, that would also have been a different matter. The court concluded that the question in this case was whether there are steps which are practically available to be taken, which, if taken, can realistically be predicted to result in the detainee's removal to a country in the reasonably foreseeable future. The failure of the detainee to cooperate in taking those steps does not detract from the fact that those steps remain practically available. ASF17's detention was continuing because of his voluntary decision not to cooperate, and this could not convert that detention into being for a punitive purpose. Now, people will probably respond to all this that it's still a cruel decision because ASF17 has a good reason to refuse to cooperate, and that is that he fears for his life if he returns to Iran because he is bisexual. He argued that this had not yet been considered by a court, including when his application for a protection visa was rejected. Well, yes, but that's because he actually had not raised it, either in the proceedings before the minister's delegate or indeed before a court on judicial review. Here it's probably useful to give some context, which is drawn from statements in a number of judgments made in relation to ASF17's previous claims, which of course remain the subject of dispute. Those judgments tell us that he arrived in Australia in July 2013 and was detained for a short period. And then he was released on a bridging visa in September 2013. Now that visa was cancelled in February 2014 when he was arrested for a criminal offence and he was sent back to immigration detention where he spent the next 10 years. During that time, he applied for what's called a Safe Haven Enterprise Visa, which is a form of protection visa. So what were his claims? Apparently, according to the documents anyway, in his entry interview on arriving in Australia, he said that he'd come to Australia to seek economic opportunity. He also reportedly said that he was an Iranian citizen and he'd done military training. Later, when applying for his protection visa, he claimed to be a stateless and undocumented Kurd. He claimed that he feared his status and ethnicity would mean he would be denied access to basic services in Iran. He sought to justify his claim to statelessness by providing a black and white photocopy of an Iranian, quote, identity card for foreign nationals, unquote, but this was later found to be a bogus document. His claims not to be an Iranian citizen were disproved by the discovery in his possession at the time of his arrest of his Iranian driver's license, which include biodata and a national identification number, which was only held by citizens of Iran. From June 2019, after all his appeals in relation to his protection visa had failed and ended, he then finally admitted that he actually was an Iranian citizen. During his protection visa process, ASF17 also claimed that he feared harm if he returned to Iran because he had converted to Christianity and he had criticised the treatment of women by the Iranian government. The primary judge found that ASF17 had adduced no evidence to show that he had opposed the treatment of women in Iran and dismissed that claim. The judge also did not accept that he had converted to Christianity. The minister's delegate had also concluded that ASF17 had only attended church services and Bible study classes to support his claim for refugee status. ASF17 was described by a judge as an unreliable witness who was prepared to concoct and adhere for a considerable period to a false version of events for the purpose of assisting his claim to protection. Now, after his protection visa claim and all judicial review and appeals had ended, ASF17 then stated that he was bisexual and that for this reason he feared harm if he returned to Iran. The High Court, in this latest judgment, pointed out that the law now barred him from making a new claim for a protection visa on this basis. Understandably, people cannot be allowed to keep making these claims forever. There does have to be an end point. However, the Minister does have a personal power under Section 48B of the Act to permit ASF17 to make a new protection claim if the Minister thinks that it's in the public interest to do so. The Minister would have to table in Parliament a statement that such a determination had been made, setting out the reasons why it is in the public interest. The Minister also has a personal power under Section 195A of the Act to grant a visa to a person if the Minister thinks that it's in the public interest to do so. Again, a statement setting out the reasons must be tabled in Parliament. The upshot of this case is that either ASF17 A chooses to cooperate and is returned to Iran, B chooses not to cooperate and remains in immigration detention, C is granted by the Minister an opportunity to claim protection based upon his new claim of being bisexual, or D is granted a visa by the Minister in the public interest. But one thing we now know from this case is that the High Court will not order his release from detention or that of others in the same category where there is no finding of an obligation of protection and where there is no issue of incapacity to be able to cooperate. The judgment is, in my view at least, consistent with the court's prior jurisprudence on the issue and therefore unsurprising. Thank you for watching the Constitutional Clarion. I hope this clarified the ASF17 judgment and these issues for you, and I look forward to seeing you next time. Goodbye.